We are going to learn misstatements in the prospectus. A contract of shares in a company is a contract of Ubermaier which means utmost good faith. The legal doctrine of Ubermaier provides that all parties to contract must deal in a good faith, making a full declaration of all material facts. The intending purchasers of the shares are entitled to trust and the trust to entitled to true and correct disclosure of all facts in the prospectus. Hence, a prospectus must make all statements with a scrupulous accuracy and not state facts which are not strictly correct. Neither any information which law requires to be disclosed to the public be concealed or omitted to be stated from the prospectus, and nor should the information given be false and misleading. Now, misstatements in the prospectus is a serious offense which attracts the provisions of Section 34 criminal liability and or Section 35 civil liability of this Act. In this section, we will learn about misleading prospectus, remedies for misrepresentation in the prospectus. What constitutes as misstatement and misleading prospectus? A prospectus is said to be misleading if it includes any misstatement. In common parlance, misstatement is the act of stating anything that is false, not accurate. A statement becomes a false statement if it produces a wrong impression of actual facts. It could either due to commission or omission or both. As per 34, Section 34, a statement included in a prospectus shall be deemed to be untrue if the statement is misleading in the form or context in which it is included or where any inclusion or omission of any matter is likely to mislead. Some of landmark judicial pronouncement only for reference and better understanding. First one is mislead through false statement prima facie of the facts. Henderson versus Lacan. It was stated in the prospectus that the directors and their friends had subscribed a large portion of the capital and they now offer to the public the remaining shares, whereas in actually each of the directors had subscribed only 10 shares. It was held that such a statement is misleading one, misled by hiding truth through superficial statements. Briggs versus Ilsant. In the prospectus, it is stated that the company had regularly paid dividends. In actual, company has been incurring substantial losses during all those years. Company used to write back some of the past provisions to the credit of the profits and loss account. It was hailed that the prospectus did not disclose the true picture of the company. Mislead through ambiguous statements. Mislead through ambiguous statements. Smith versus Chadwick. The prospectus of manufacturing company contain the present value of turnover is 1 million sterling per annum. The statement was true only if the production capacity is considered, but untrue if it means the present production level, capacity in utilization. It was held that such a statement which director knew may bear multiple meaning out of which in can be false to their knowledge and considered to be punishing of misleading statement. Effect of misleading prospectus, remedies of misrepresentation. The fear of heavy liability and criminal sanctions have controlled the director's tendency of using extravagant terms and flattering descriptions. Just a second. Okay. So the fear of heavy liability and criminal sanctions have controlled the director's tendency of using extravagant and flattering descriptions, extravagant terms and flattering description. But if the prospectus contain a misleading or false statement or omits to disclose a material fact which amount to the misrepresentation, the aggrieved shareholder has the remedies. The law allows the following remedies for misrepresentation. Remedies for misrepresentation in prospectus. One is against the company, where the intended aggrieved shareholder can use the right of rescission or right of damages. And against the company and others, there is a civil liability where he can get a compensation. And against the persons authorized to issue prospectus, there are two remedies. One is criminal liability, and another is damages for deceit. Remedies of rescission, damages, and deceit are not specified in under the Companies Act. They are available under the Indian Contract Act 1872, read with relevant provisions of the Specific Relief Act 1963. Whereas the criminal and civil liability is provided under Section 34 and 35, respectively, of this Act. Since remedies specified above are alternative courses, hence all of these remedies are not available simultaneously. Whereas appropriate combination of these can be claimed. Now here we can say that to illustrate claim for compensation under Section 35 civil liability of this Act being special statute where a jurisdictional power is vested in NCLT shall not be moved simultaneously with claim for damages under general provisions. Right of rescission. When to seek rescission, a person who has purchased shares from the company on the basis of the prospectus containing untrue and misleading statements of material facts is entitled to apply to the court for rescission of the contract under the relevant provisions of the Indian Contract Act 1872. Effect of rescission. The agreement to take up shares is voidable at the option of the subscriber to the shares. It will remain valid unless he actually resigns it. If the court accepts his application for the repudiation of the contract, company will remove his name from the register of the members and return his money with interest and other incidental cost. Entitlement to compensation for any damages which he sustained through the non-fulfillment of the contract arises under Section 75 of the Indian Contract Act 1872. Exception when the right of rescission is not available. Right to rescind allotment of shares will not be available to the subsequent purchasers of shares from the market. A subscriber to the memorandum of association cannot also seek any relief as the company cannot be considered to be in existence at the time when he appended his signatures to the memorandum of association. So he cannot be said to have been influenced by any statement in the prospectus. Now, all the statements contained in a prospectus issued by a company were literally true. It was also stated in the prospectus that the company had paid dividends for a number of years, but there was no disclosure regarding the fact that the dividends were paid out of the realized capital profits and not out of the trading profits. An allotee of shares wants to avoid the contract on the ground that the prospectus was false in material particulars. So the non-disclosure of the fact that the dividends were paid out of the capital profits is a concealment of a material fact, as a company is normally required to distribute dividends only from the trading or revenue profits, and under the exceptional circumstances it can pay dividend out of the capital profits. Hence, material misrepresentation has been made, and accordingly, in the given case, the allotee can avoid the contract of allotment of shares under his right of procedure. Now we'll see the right of action for damages. When to evoke. In the cases where misstatement amounts to fraud, aggrieved investor also gets the right of action for damages against the company. This right is available even after the company has gone into liquidation. Prerequisite to claim for damages, misrepresentation. It should be a fraudulent misrepresentation was there in the prospectus and it is of a material fact. A person is intended to act upon it, and person suffer the damages as the consequences of acting upon such fraudulent misrepresentation. Civil liability for misstatements in prospectus, Section 35, offense under Section 35. Loss or damage to subscriber of security as a consequence of acting on the basis of the inclusion or omission of any matter in the prospectus which is misleading the subscriber or subscribers. Who shall be held liable? A company and every person who is or has a director of the company at the time of the issue of prospectus authorize himself to be named and is named in the prospectus as a director of the company or has agreed to become such director either immediately or after an interval of time. Then a promoter of the company who has authorized the issue of the prospectus, an expert referred to in subsection 5 of section 26, which we have learned earlier. Now we will see that liability for an offense under section 35. A person found guilty under section 35, in addition to any punishment under section 36, a company and every other person shall also be liable to pay compensation to every person who has sustained loss or damage. Exception to liability for guilty or offense under Section 35, subsection 2. Subsection 2 provides the instances when a person shall not be held guilty under Section 35 of this Act and if he proves that he withdrew his consent to be a director of a company and prospectus issue without his consent and authority, and he has given a reasonable public notice to effect that the prospectus was issued without his knowledge and consent. He made the statement on the authority of an expert whom he believed to be competent and that the expert had given his consent and had not withdrawn it. And he had reasonable ground for believing believing the statement to be true and that he did believe it to be true up to the time of allotment. The statement was a correct copy of some extract from an official document and that he had in fact believed. Now, personal liability when intended to defraud in subsection 3 of section 35. Every person referred under subsection 1 shall be personally responsible without any limitation of liability for all or any of the losses or damages that may have been incurred by any person who subscribed to the securities on the basis of such prospectus. Where it is true that the prospectus has been issued with the intent to defraud the applicants for the securities of the company or any other person or for any fraudulent purpose, in that case, that he has the compensation need to be and the liability, the compensation should be given and the personal liability intent. Now here we will see the illustration where a prospectus issued by a company contains certain misstatements. On becoming aware of the fact regarding misstatement in the prospectus, one of the experts stating that the prospectus was issued without his knowledge and consent, and is it possible for Anilesh to escape the liability for misstatement in the prospectus? So here we have seen that there is an expert who had earlier given his consent and forthwith gave a reasonable public notice, who had Alinga forthwith gave a reasonable public notice stating that the prospectus was issued without his knowledge and consent. So here we can say the Section 35(2) of the Companies Act 2013 states that no person shall be liable under subsection 1 if he proves that the prospectus was issued without his knowledge or consent and that on becoming aware of its issue, he forthwith gave a reasonable public notice that it was issued without his knowledge or consent. In this case, Anilesh is covered under the above exception provided by section 2 of subsection 2 of section 35. Therefore, he will escape the liability for misstatement in the prospectus. Now we'll see the criminal liability under section 35 for the misstatement in prospectus. Offense under such section 34 where the prospectus issue circulated and distributed that includes any statement which is untrue or misleading in the form or context in which it is included and wherein an inclusion or omission of any matter is likely to mislead. Who shall be held liable? Every person who authorized the issue of such prospectus and liability for an offense under Section 34. Such person found guilty under Section 34 shall be liable for punishment under Section 447 of this Act. Exception to liability for guilty offense under Section 34 provided to Section 34. Provided to Section 34 provides that the instances where a person shall not be held guilty under Section 34 of this Act if it proves that such misstatement or omission was immaterial or he had reasonable grounds to believe that did up to the time of issue of the prospectus believe that the statement was true. Sorry. Or the inclusion or omission was necessary. Loss from misstatement is not essential to hold a person guilty under Section 34. Liability for offense under Section 34 is a strict liability, hence it is immaterial where the omission is intentional or unintentional. In both cases, in the both case, person will be held guilty under Section 34 and liable for punishment under Section 447 of this Act. Summary of Section 35 and 34. The liability for misstatement. One is criminal liability under Section 34 and civil liability and T under Section 35. So here we are saying that Section 34 deals with the criminal liability and Section 35 deals with the civil liability. In the civil liability, company director and proposed director or promoters expert and one who authorized or for the issue of prospectus have to pay compensation to investors who incur the damages due to relying on the prospectus issue. There are differences and exception where if the person withdrew his its content to be a director and believe on consent under Section 26, subsection 5, an issue without his knowledge and public notice, reasonable public notice have been given by him. And every person who authorized for issue of prospectus, criminal liability, every person who authorized for the issue of prospectus are punishable under Section 447, and defenses are there if mm, those facts given in those false and misleading information is immaterial and reasonable or it was earlier reasonable ground to believe there was a reasonable ground to believe on those information provided in the prospectus. Now here we will see an illustration, an alert of a shares in a company brought action against the director in respect of false statement made in the prospectus, and the director contended that the statements were prepared by the promoters and he simply relied on them. Is the director liable under the circumstances? Yes, the director shall be held liable for the false statement made in the prospectus under Section 34 and 35 of the Companies Act 2013, whereas the Section 34 imposes the criminal punishment on every person who authorized the issue of such a prospectus, and Section 35 more particularly includes a director of the company in the imposition of a liability for such misstatements. Certain situations where when a director will not incur any liability for misstatement in a prospectus are covered under exception provided by Section 35, subsection 2, but so no such exception specifies that relying on the statements prepared by the promoters of the company is a valid ground for a director to escape liability for misstatement. Damages for deceit. When remedy of damages for deceit is available, persons responsible for the issue of a prospectus can also be held liable in an action for deceit under general law as provided by Section 19 of Indian Contract Act 1872. Here they have said the person responsible for the issue of person can also held liable in an action for deceit. Action for deceit. Previously, we have seen the action for damages. Now we are seeing the action for deceit under general law as provided by Section 19 of the Indian Contract Act 1872. Now, this remedy shall be available even where the remedy by way of rescission as against the company is lost either through the laches or negligence or even if the company goes into liquidation. Perquisite to claim damages for deceit is available if there was a fraudulent misstatement related to some existing material facts and he is his original authority and had seen the prospectus and he has been actually deceived. Peak versus Gurney, the Gurney issued a fraudulent prospectus on behalf of the company. No shares were purchased by Peak at that time, and several months afterwards, Peak purchased 2,000 shares of the company from the stock exchange. Now, he brought an action against the directors of the deceit on the basis of the prospectus. Quote, "Hey, the directors were not liable as the shares were not purchased on the basis of the prospectus." Now, punishment for fraudulently inducing persons to invest money. That's Section 36. Any persons who either knowingly or recklessly makes any statement, promise, or forecast, who makes any statements, promise, or forecast which is false, deceptive, and misleading is false, deceptive, and misleading, or deliberately conceals any material facts to induce another person to enter into or to offer to enter into in any agreement for or with a view to acquiring, disposing of, or subscribing for, or underwriting securities or any agreement, the purpose of the pretended purposes of which is secure a profit to any of the parties from the event of security or by reference to fluctuation in the value of securities. Any agreement for or with a view to obtaining credit facilities from any bank or financial institution shall be liable for action under Section 447. And huge sums of money were collected under a document described as Project Overview by NRI, but shares not allotted in the proposed joint venture company instead of money was diverted to some offshore companies controlled by the accused person. Prima facie offense under Section 36 made out. Now we will see the actions by affected person, 37. A suit can be filed or any other action may be taken under Section 34 and Section 35 or Section 36 by any person or group of person or any association of persons if affected by any misleading statement or the inclusion or omission of any matter in the prospectus. Illustration: EM applies for equity shares of a company on the basis of prospectus which contains a misstatement, and the shares are allotted to him who afterward transfer them to Yen. Whether the Yen can bring an action for a rescission on the ground of misstatement under Section 37 of the Companies Act? No. Yen cannot bring an action for rescission of the contract for buying his shares from Yen on the ground of misstatement made in the prospectus. Section 37 of the Companies Act 2030 does not become applicable in such situation. It is noteworthy that according to the Section 37, a suit may be filed or any other action may be taken under Section 34, Section 35, or Section 36 only if any person or group of person or association person and affected by any misleading statement or inclusion or omission of any matter in the prospectus. Prospectus, therefore, only M is eligible to file the suit. Now we'll see the Section 37 has paved way for class action. A class action suit is for a group of people filing a suit against a dependent who has caused common harm to the entire group or class. This is not like a common litigation method where one dependent file a case against another dependent while both other parties are available in the court. In the case of class action suit, the class or group of people filing the case need not be present in the court, can be represented by one petitioner. And the benefit of this type of suit is that if several people have been injured by one defendant, each of the injured person need not to file a case separately, but all the people can file one single case together against the defendant. Now we will see the punishment under Section 38 for personation for acquisition of securities under Section 38. The purpose of the section is to prevent allotment of shares in a fictitious names. Here, let us Subsection 1 provides any person shall be liable for punishment under Section 447 if he makes or updates the making of an application in a fictitious name to a company for acquiring or subscribing for its securities, or he makes or updates the making of a multiple application in different names or different combination of his name or surname for acquiring or subscribing the securities, or otherwise induces directly or indirectly a company to allot or register any transfer of any securities to him or to any other person in a fictitious name. Subsection 2 provides that every company which issues a prospectus is required to reproduce permanently the provisions of subsection 1 in the prospectus and every form of application for security. A person who gets shares allotted in a fictitious name becomes liable as a shareholder, thus where a person carried on a business under an assumed name and took shares in that name, his trustee in bankruptcy of the said person could not avoid liability. Now, subsection 3 provides where a person has been convicted under section, the court may order this dischargement of any gain made by such person, and the order may also include seizure and disposal of the securities which may be found in his possession. The amount received through dischargement or disposal of securities under subsection 3 is to be credited to the Investor Education and Protection Fund as subsection 4. Now we will see punishment for fraud under section 4.